Good morning and welcome to our first webinar for 2025. My name is Neil Kutza. I'm the head of the employment practice at CHM. Thank you all very much for joining us. We've had a fantastic response, almost 400 registrations for this webinar, so we're very excited about that. What we've decided to do is to hold an annual webinar under the "In Case You Missed It" theme, simply because there's so much happening on even a daily or weekly basis in labor law and industrial relations. So it can be a little bit overwhelming, even for lawyers, but we need to stay on top of these things. So this webinar is really a chance to kind of slow down, take stock, and allow your favorite employment attorneys to take you through the most important developments in employment law from the last year. So what we intend to do today is to touch on developments from collective bargaining and strikes, public sector employment relations, misconduct, retrenchments and Section 197 transfers, discrimination, restraints of trade, and then at the end, we'll also look ahead briefly to what 2025 holds. And then next year, we'll chat about whether we were right about some of those things. You'll see from the content that we've tried to cover as much as possible, but obviously there's only so much we can deal with in 90 minutes. This was originally scheduled for 60, but we realized during our planning phase that 60 minutes just wasn't going to cut it, and it was going to feel quite rushed. So the webinar will also be available on our YouTube channel afterwards, where you can watch it in the bath with a cup of tea or a whiskey. But please, I would encourage you to rather stay with us. If you do stay with us for the full duration, you'll be able to impress all your colleagues afterwards about your knowledge of employment law. Just another thing is that we won't be taking any questions today, partly because of the time limits. But if you have any arising from the webinar, please feel free to contact us. We'd be more than happy to answer your questions. So let's get on to the webinar. We'll start with collective bargaining and strikes. Unfortunately, I have to deal with that one, but it is an area of interest for me. So what we have seen, just at a general level, not only in relation to collective bargaining and strikes, is that litigation may not be the best option for anyone, even if you believe your case is a good one. We've had several cases in the last year with some surprising outcomes, causing a lot of debate and uncertainty. Enova is one of those cases, and that case dealt with the use of marijuana outside of work and whether it's relevant to the workplace. What makes employment law complicated, of course, is that we deal with fairness in employment disputes. So this concept is all a little bit nebulous, and it generally works on a sliding scale of fairness. And you'll know when something is unfair immediately, but that threshold is reached at different points for different people. And so for this reason, I think that litigation in employment is always a much bigger roll of the dice than in other areas of law. So on collective bargaining, I think that the biggest case to come out over the last 12 months has been that of AFGRI Animal Feeds versus NUMSA and others. So here, the Constitutional Court clarified once and for all that unions are bound by their constitutions, and any acts which fall outside the scope of those constitutions are null and void. In AFGRI, the Constitutional Court was asked to determine whether NUMSA could represent persons who could not be its members in unfair dismissal proceedings. Those persons could not be NUMSA members, the employer said, because NUMSA's constitution did not permit it to recruit members from the agricultural feeds industry. And the Constitutional Court made it clear, unions must comply with their constitutions. If they do not, those acts are null and void. If a constitution does not permit NUMSA to have as its members persons from the agricultural feeds industry, then it could not represent them in collective bargaining processes or in any disputes at the CCMA, Bargaining Council, or Labour Court. Now, this may seem obvious, but this was not always the case. Our law, up until AFGRI, permitted employers to query whether a union was authorized to represent employees in collective bargaining disputes, but not in unfair dismissal disputes. That distinction was one made by the Labour Appeal Court in McDonald's transport, and it was entirely artificial, and frankly, it just complicated things. So I think this is an extremely important judgment for everyone, because for too long, and we've all, at least at CHM, spoken about this for some time, that unions have been allowed to escape the consequences of their actions for far too long. And it's about time that they are held, at least to their own constitutions, as a starting point. But before we get too excited, we must realize that there's, as usual, a problem. The Constitutional Court in this case has told us that a union's non-compliance with its constitution amounts to an act which is null and void. So that means that non-compliance with the union's balloting provisions before a strike should then render any strike or strike notice null and void as well. But that's not true. So Section 67.7 of the LRA still says that a strike is protected even if a union does not comply with its own balloting requirements. So the law as it stands is that unions must comply with their constitutions, but they can safely ignore the balloting provisions, you know, the ones that they're required to have before they engage in a strike. So it's these sorts of anomalies that make it incredibly difficult for employers and also for labor lawyers. Another important judgment, I think, was that of Sakawu and Massmart. Now, the case raised the issue of whether an employer could claim just an employer could claim just an equitable compensation from a union whose members had engaged in unlawful conduct during a protected strike. The Labour Court had said yes, there's no problem with that, so of course the matter went to the Labour Appeal Court. The judgment turned on an interpretation of various sections of the Labour Relations Act, which is all much too boring to discuss in this webinar, but the short version is this. The Labour Court has jurisdiction under the Labour Relations Act to entertain a claim for compensation by an employer where a union's members have engaged in unlawful conduct during a protected strike. The fact that the strike is protected does not magically absolve the union from such a claim under the LRA. So this is another very useful judgment, holding unions accountable for their actions. And I think personally, bravo to the Labour Court and the Labour Appeal Court on this one. What it does is to open up a channel for employers to pursue claims for compensation against unions, even when a strike is protected. And they can do that in the Labour Court and in terms of the Labour Relations Act. So not only through a common law delictual claim, which I think is very, very important. So hopefully this will ensure greater accountability for unions, but employers will of course have to hold them accountable. It doesn't happen magically on its own. Employers will still also have to prove an entitlement to the compensation they may want to claim. In this case, it was about 9 million. So no determination has been made in that judgment, as far as I'm aware, as to whether the union is actually liable for that amount or whether the employer is entitled to compensation. The next matter is Ekapa Minerals versus NUMSA. And here the Labour Court had to deal with a contention by the employer that a breach of picketing rules rendered a strike unprotected. Now, those who follow labour law closely will know that many years ago, the Labour Court and some commentators suggested that a violent strike could lose its protected status, but there was no definitive judgment that ever emerged on this issue. And I think most of us thought that this issue had been consigned to the rubbish bin of history, but in recent times, we've had two judgments that have raised this issue again. So the Labour Court here, again, was not swayed by this argument. It correctly said that a breach of picketing rules is just that. It's a breach of picketing rules and nothing more. It doesn't change the status of a strike. It said that while there were clearly breaches of the picketing rules by the marshals who carried sticks during the picket, this did not render the strike unprotected. The defense from the union, by the way, just as a matter of interest for why the marshals were carrying sticks, was to ensure that the strikers behaved themselves during the strike, which the Labour Court obviously rejected as a defense. And then about a week ago, we saw another instance of this sort of litigation where an employer sought to have a protected strike declared unprotected in the Durban Labour Court. And this was the Container Depot's judgment. It was doing the rounds on LinkedIn. And everyone was outraged initially, but I think once you read the judgment, it makes perfect sense. The Labour Court again correctly said in that judgment that you could not declare the strike unprotected because of violence. And in that case, 3 murders had taken place. So while it may offend the morals, it doesn't change the legal position. And I think employers would be well advised to rather consider asking the Labour Court to suspend the picket and vary the picketing rules where there are breaches. And then lastly, for my section, the Constitutional Court's judgment in Moloto a few years ago seems to have created the impression that a strike notice is immune from challenge by an employer, but this is not the case. And the Labour Court recently in 2024 gave a judgment in Road Accident Fund versus NUMSA, where it restated that a strike notice had to give the employer a clear indication of what it must agree to if it wishes to avoid the strike. It must state the demands clearly and crisply, even if the employer has an idea of what they may be about. So even though the employer may conceivably know, in this case, it was from a press release that was made and also the issues they'd been dealing with before the notice arrived. So the employer had an idea, but it hadn't been articulated in the strike notice properly. And here the Labour Court found that the failure to do so rendered the strike unprotected, and the union could issue a new strike notice, of course. They were not prevented from doing so. But it's important for unions to comply or to issue a strike notice which is clear and can be understood by the employer. So I've dealt with about 4 or 5 cases there in a whirlwind. There are about 3 others that I wanted to deal with, but unfortunately we just don't have the time. The next topic is one that everyone loves because it's not something that is specific to any particular employer. It's misconduct, and everyone's employees misconduct themselves equally. So I'm going to hand over to my colleague, Gail Barrable. She is a partner in the employment practice. Gail, you can take it away.
Thanks, Neil. Great. Okay, I also prepared for this webinar by going through as many cases as I could, and I identified about 7 cases that I felt would be of interest, but unfortunately I'm not going to be able to cover them all. So I'm going to just basically focus on 4 cases that I think may be of interest to everybody. The first one deals with dishonesty and the issue of consistency. It's the case of Supreme Poultry and Ruddy Bokeh. I see there's a request for citations. I'm sure we'll be able to send those to you. This was a decision of the Labour Court. Obviously, what happened here is that the individual employee had been charged with dishonesty for claiming overtime hours that he had not actually worked. I think this is quite a common problem. Also, where employers are not actually recording their time accurately, he was clocking in and claiming overtime hours when they were actually not due to him. So this led to his dismissal for gross misconduct. The matter ended up at the CCMA, and the arbitrator was quite sympathetic with the employee, ordering reinstatement with retrospective effect. So the commissioner here reasoned that, which is something we find quite often, that there are different levels of dishonesty, and came to the decision that this particular act of the employee didn't warrant dismissal. The issue of consistency was raised as well. The employee had argued that other employees, in particular managers who had sort of been responsible for approving his overtime claims, etc., they didn't receive dismissals. They received warnings, and he said this was unfair and inconsistent. Also, on a procedural side, the employee had argued that there was insufficient notice given to him of the specific charges. So as I say, the commissioner was sympathetic towards him. The matter was taken on review to the Labour Court, and fortunately for the employer, the decision was set aside, and the court ruled that the dismissal was fair both substantively and procedurally. So the key findings here is that the court found that this argument of varying degrees of dishonesty is nonsense. Essentially, he was being dishonest in claiming overtime. This was a serious offense. It was undermining the trust relationship between the parties, and clearly this warranted dismissal. On the issue of inconsistency, which the employee had argued, the court found that at the arbitration proceedings, the employee had actually abandoned that issue, which is significant for me in the sense that when you take these matters on review, often the record gets transcribed, made available, and you have to wonder, does the court actually study those records? And I think this answered my question, because the court studied the record and found that because the employee had actually abandoned that point before the proceedings even commenced, he found that it was entirely irregular for the commissioner to resurrect this issue and use that as a basis for his finding. So that was clearly incorrect. And then on the issue of procedural fairness, the court found in favor of the employer and said that the real question to be determined with procedural fairness is whether there has been any material prejudice to the employee. And the court found that there hadn't been in this case. But the next case, I think this has also been doing the rounds on LinkedIn and social media. It's the case of Woolworths versus CCMA and others. And the others here is Ms. Maseko. So what happened here? This employee was dismissed for misconduct, and she was charged with breaching company policy and procedures in submitting irregular medical certificates from a suspected bogus doctor. So what happened here is that she had actually applied for sick leave 2 years prior to this, but had used the same, or at least had provided a medical certificate from the same practice. And then Woolworths got wind of the fact that this particular practice was not entirely savory. They conducted an investigation and found that this doctor, whose name was Dr. Frempong, but unusual, was in fact allegedly selling medical certificates. And I think this is not an uncommon problem. I've come across it in my practice as well. And so ultimately, also his practice was very dodgy. I mean, there weren't proper consulting rooms, there was very little privacy, and essentially it was just not ideal situation. So the employer decided to charge her with producing an irregular certificate. So the matter ended up at the CCMA. And very interestingly here is that Dr. Frempong actually testified on behalf of the employee. And also found that unusual, because to get medical doctors to come and testify generally doesn't happen. But for Woolworths, this was actually a problem, because he testified and produced proof that he was qualified as a doctor in Cambridge University. He produced proof that he was registered with the HPCSA. And unfortunately, Woolworths didn't have any evidence to contradict this. So with this very damaging evidence, the commissioner found that there was no evidence to suggest that the employee was not ill, or that the certificate that she produced was issued by an unregistered doctor. So the commissioner found in favor of the employee, and she was awarded compensation. So Woolworths decided to take this on review, and they were successful in the Labour Court, which set aside the CCMA decision, saying that the commissioner had failed to apply his mind to all the evidence. The employee took this to the Labour Appeal Court, and the Labour Appeal Court actually overturned the Labour Court's judgment. And the court emphasized here that the employer had been unable to establish that the employee had knowledge that the certificate was irregular. In the court's reasoning, the employee was the innocent victim here, so to speak. She had no idea that there was anything untoward. In her mind, she was sick on that occasion and obtained a legitimate certificate. So essentially, I think the problem here is that Woolworths was unable to contradict the evidence of Dr. Frempong, which created big problems for them. So the legal principles really that we can extract from this case is that dismissals for misconduct must be based on clear, provable facts. A suspected irregularity, and no doubt there were irregularities going on with this practice. But a suspicion around that does not equate to the employee being liable, unless you can show that the employee is knowingly participating in that irregularity. The next case ended at the CCMA, and I've chosen this case because again, I think it's important about emphasizing how employers bear the onus of proof and how they need to be organized and prepared for their appearances in the CCMA and being in a position to defend their decision to dismiss an employee. So this is a case of Lawson versus Standard Bank of South Africa. And Christine Ann Lawson was employed at a senior level. She, in fact, was the head of compliance for global markets at Standard Bank. And she was dismissed on allegations of gross misconduct for allegedly creating a psychologically unsafe workplace. So this stemmed from complaints from subordinates within her team that she was bullying and harassing them, and she was just an unpleasant person to work for. They alleged that many employees had left because of her management style and generally her attitude towards people. So the matter ended up at the CCMA, and Senior Commissioner decided the matter, and she ruled in Lawson's favor. What's interesting here is that the bank called 5 witnesses and Lawson called 4 of her own witnesses. So substantial evidence that is being bandied about. But the commissioner here was very, very cautious about this evidence. And she found that the investigation that led to Ms. Lawson's dismissal was not impartial. So the investigator at that stage had focused on the complaints from the various team members or subordinates, and he or she had failed to have regard to evidence from other members of the team. So more than likely the 4 witnesses that testified at the arbitration. Their statements were not sought. They weren't approached to come and give evidence. So the commissioner found that investigation was entirely biased. Also, the commissioner found that having sort of analyzed the evidence of all 5 witnesses, she found that their testimony was in fact, she concluded that the witnesses were oversensitive, highly strung, and not entirely truthful. So in conclusion, she found that there was no credible evidence to support the claims of misconduct. So essentially, the outcome there is that Lawson was awarded almost 1.7 million in compensation for this dismissal. So I think this case emphasizes again that employers need to have credible evidence. Obviously, they bear the onus to prove that the dismissal that they've chosen is the correct route, and they need to support that with proper evidence. You can't go in with baseless assumptions because it's going to cost you. And then the last case that I'm going to talk about is the matter of running out of time.
Yeah, we're running out of time. So
okay.
Let's do those 3. And I just have 1 or 2 questions that I want to ask you. You've been through, obviously, the misconduct cases for the year. Did you pick up any trends or themes that are appearing in the cases?
Yeah, look, I think in terms of what type of cases are the courts are dealing with, I can't say with any accuracy. There are no real stats available, but clearly things like dishonesty, insubordination, creating a hostile environment, I think those are quite common. But I think what stands out for me, and the next case I was going to touch on, just essentially what comes out there is that employers need to be sure of their facts and their evidence. So I think that's what we can take out of these cases, is be prepared. And I personally am in favor of, if you're going to dismiss an employee, focus on 1 or 2 charges that you believe are strong, that you can support, you can prove, rather than come with a flurry of charges and end up not being able to substantiate that later.
And then there's a draft code of good practice that's been published recently. We don't really have time to get into it, but maybe you could just highlight one or two of the major changes that you've picked up in the draft.
Okay, I think that the draft, in my view, simplifies the existing code. I think it uses simple language. It's a lot shorter. However, it does incorporate retrenchment, which wasn't in the previous code. It's essentially on the same lines as the previous code, but it is in simpler language. I think one of the major things that I've picked up here is that there's a reference to small business. And there's an acknowledgement that small businesses do not have the infrastructure, they don't have the time to follow elaborate, lengthy, and formal pre-dismissal processes, at least. So small business is not actually defined, but in my understanding, if we look at the ministerial determination that it was issued under the BCA, it defines small business as an employer with less than 10 employees. So I think that's quite an important innovation here. There's an acknowledgement that small employers need to have some flexibility on how they deal with dismissal. So yeah, there are others. I don't know if I have time to mention one other point. No.
No,
Perfect.
unfortunately
Talk
not.
to you later.
Perfect.
All
Thanks,
right.
Gail. Thanks very much.
Okay,
That's
thanks, Neil.
all right, our next speaker is going to deal with some public sector developments. And that is Mbulelo Ndlovu. She's just recently been promoted, so she will be a partner in our public law risk and governance team as from the 1st of March. Lelo, over to you.
Thanks, Neil. Morning, everyone. So I will try and be brief. So I'm going to discuss firstly the Mbambisa versus Nelson Mandela Bay Metropolitan Municipality. Succinctly, the facts of this matter are as follows. In February 2014, certain officials within the municipality appointed a consultant to develop a comprehensive communication marketing strategy without following the proper procurement processes. The municipality paid an amount of about 7 million pursuant to that appointment. Thereafter, the municipality proceeded to conduct an investigation and found that the appointment of the consultant was irregular. In February 2016, the municipality instituted action against, amongst other people, the officials who were involved in the appointment of the consultant, as well as the consultant, to recover monies which were spent in that contract. The High Court held that Section 32 of the Municipal Finance Management Act creates a statutory claim for the recovery of unauthorized, irregular, or fruitless and wasteful expenditure from officials for such expenditure as a penalty and not as a damages claim. It further found that Section 32 creates a self-standing claim based on jurisdictional requirements contained in the provisions, and that the municipality is statutorily obliged to recover unauthorized, irregular, fruitless, and wasteful expenditure from persons who commit such acts. So, agreed by the decision, the officials then appealed the decision in the SCA. So interestingly, the SCA found that, agreed with the High Court, and they found that Section 32 is a self-standing penalty provision in terms of which the municipality is obliged to recover the full extent of the prescribed expenditure from the relevant officials, regardless of whether the municipality has sustained any loss or damage, and irrespective of the extent of such a loss. The SCA accordingly was required to give a proper construction of what Section 32 of the MFMA entails. Whether the municipality was precluded to institute action against officials on account of unreasonable delay was also another factor that the SCA had to consider. So in considering the interpretation of Section 32, the SCA applied a contextual and a purposive interpretation. The SCA reiterated the point that it has to use a plain language, and therefore it emphasized that the words cannot be read into a statute by implication unless that implication is necessary. It further held that it is not helpful to characterize Section 32 as a penalty provision. So in the nub of this case is that you can run, but you can't hide. So in essence, if you are found guilty of misconduct, in addition to that, the municipality is also going to recover whatever monies that is due or that was incurred as a result of such misconduct. Secondly, I'd like to discuss the Chabalala versus Mokaka local municipality and another. So in this instance, the employee was employed by the municipal as a municipal manager. She was placed on suspension on the 1st of March, pending investigation. And she then received a notice on the 31st of May. And then on 3 June, she then reported for work. There were exchanges between the various parties' legal representatives. And then the issue of this matter is okay, let me just get through to Regulation 6, which will establish what the nub of this matter is about. So Regulation 6 provides that precautionary suspension of a senior municipal employee and states that if a senior is suspended, a disciplinary hearing must commence within 3 months after the date of suspension, failing which the suspension will automatically lapse. So the issue raised by the employee is the fact that I've been on suspension for longer than 3 months, and therefore I have to come back to work. So she then lodged an application in the Labour Court, whereby the Labour Court held that the disciplinary hearing commences when the charges and the notice of disciplinary hearing are served on the employee, and thus his suspension had not lapsed. Dissatisfied with the Labour Court's decision, the municipal manager appealed, and the Labour Court was tasked with clarifying what constitutes the commencement of a disciplinary proceeding. The central issue was whether a disciplinary hearing begins when the municipality serves the charges of alleged misconduct or when the officer presenting the evidence reads out the charges at the convened hearing. The municipal manager argued that the Labour Court had failed to distinguish between the commencement of the disciplinary proceedings and the commencement of the disciplinary hearing. A disciplinary hearing is an integral part of the disciplinary process or proceedings. It does not constitute the proceedings in themselves. This is what the Labour Court held. Read sequentially, the regulations contemplate that the disciplinary hearing is convened by the presiding officer and commenced by the reading of the charges to the senior manager of misconduct. The Labour Court found merit in this argument, agreeing that the disciplinary proceedings may start with the issuance of the charge sheet. So in essence, public officials, whether in the municipal areas or in the public sector, they have to ensure that disciplinary actions are taken within a speedily manner. I'll hand back to Neil.
Thanks, Lelo. That was very speedy. Well done. Look, you do a lot of work in the public sector. And, in the media, we read about various state-owned entities or municipalities which have suspended employees. Do you get the sense that there is an attempt to hold public officials to account? In the first judgment you spoke about, it seemed like there was a push to do it. Do you see it happening more?
Certainly. I think with this case, it does provide somewhat of a relief and also a warning to public officials, employees, that they are not above the law. So whether the municipality or public entity has benefited from a contract, they will be held accountable for whatever expenditure that was incurred. So we have mechanisms in place, such as the PFMA and oversight bodies. So therefore, this case has just reinforced the importance of those mechanisms in place. So as I said earlier on, public officials can run, but they cannot hide because they will be held accountable for those monies. Remember, this is also your money as a taxpayer. Yeah. So therefore, there has to be some form of accountability in place.
Yeah, I think I agree with that wholeheartedly. And then another thing we hear about is the sort of formalistic slow disciplinary processes that happen in the public sector. Do you think that, I mean, bearing in mind that we need to hold people accountable, especially because they oversee public funds, do you think that there's room to expedite the disciplinary proceedings in the public sector?
Certainly, but at the end of the day, disciplinary hearings most often than not, I mean, it's the same as in the private sector. There's no difference. It's just that we are governed by other statutes besides the Labor Relations Act. But, we find that, disciplinary hearings are lengthy and they become unnecessarily bogged down because of technical or procedural issues. Unfortunately, labor relations, provides that, that the procedure has to be fair. So it's a matter of striking a balance and also creating a buffer in the policy of the organization. And I mean, there's so much you can do. So also, we can also hold the inquiry by way of a stated case. That's also another option to try and expedite the process. But otherwise, there's so much you can do.
I think the default position is that lawyers are usually involved, and that may be the reason it takes so long. But anyway, thanks, Lelo. That was great.
Thank you.
All right. So the next issue that we'll be dealing with is discrimination, and the next two sections, this one on discrimination, and then also the next one will be dealt with by two of our Cape Town partners. First one up is Jeanette Flock. She's a partner in our employment practice in the Cape Town office. Over to you, Jeanette.
Thanks, Neil. Okay, so I saw there's a lot of comments about the citations. The citations will be on the YouTube channel. So you can go and search for the full citation when it's posted. The first issue on discrimination that I'd like to touch on is the legalization of the use of dagga. We've seen a lot of employees who basically think that because it's legal, I can smoke dagga at home and there's no way that an employer can limit when I do that and whether I in fact do that. The starting point is the same as with alcohol. So even though it's legal, that doesn't change the fact that it's got an intoxicating effect. And just as is in the case with alcohol, employers can still set the rules and limits that apply to their workplaces, but that must be linked to the inherent requirements of that workplace. We had two interesting judgments coming through. They were all over social media, so I'm sure that most of you would have seen some debate on these judgments already. The first one is the Marassi versus Petro SA judgment, which is a Labour Court judgment from June 2023. And then the second one is a Labour Appeal Court judgment of Enever versus Barlow World, which is November 2023. In the Marassi judgment, this is actually a judgment or a trial that I ran myself in the Labour Court. And I think just from a practical perspective, when dealing with this case, the interesting things to note were that the employer in this case didn't go with a zero tolerance policy. What they instead did is they took specific cut-off limits that they linked to international standards. And because alcohol and dagga reacts in different ways with your system, so when you use alcohol tonight, you will not necessarily test positive tomorrow. When you use dagga 6 weeks, or if you use dagga today, in 6 weeks' time, you could still test positive for the dagga. What this means is there's a difficulty in testing whether a person is actually impaired. So whether they are intoxicated when they are at work. Petro SA used these cutoff limits because what they show is when a person is likely to be impaired. So there's no way that you can say a person is intoxicated when testing dagga. Obviously, the general case is not, or general examples are not where employees just show up at work and you can clearly tell that they are laughing or they are reacting and they are therefore high, so to speak. What employers usually deal with is you can't really tell whether the person is impaired. And that is why Petro SA set these specific cut-off limits that they're based on the international standards. a big focus of the evidence that was led in that case was on the inherent requirements of the position. So why was it necessary for health and safety that the person had to test below these cutoff limits? And days and days were spent on actually explaining in detail what this person as a telecommunications specialist had to do. We're talking, this is not just someone who had to make sure that the phones worked. This is someone at a refinery who had to make sure that the emergency telephones worked. That person had to go into the actual bunkers on site to check the telephones. That person had to climb up certain ladders to check that the lines were spun correctly. That person had to sometimes get in a helicopter and go to the telephones that were on the rigs out in the sea, or in the, go to the harbors where there's very strict health and safety requirements. So the Marassi case showed us how important it is to look at the actual detail of what this person is going to do and not just the job description. Another interesting thing that came through in this case was the test that had to be conducted. I see there's a complaint that it's a bit rushed. I'm going to slow down a little bit. When employers look at which policies they need to impose, there's different tests on how you test for cannabis usage. And when I say cannabis usage, you can't really test for intoxication. You are testing whether there's a presence of this drug in the person's system and what the level of impairment is. So we've got tests that are like a panel test, which is a pregnancy test. It says either positive or negative. Then you've got saliva tests, which are a bit better in terms of showing more recent use. You've got blood tests, which some of the blood tests just show the presence of cannabinoids. And the difficulty with those tests is you can pick up if someone used cannabis oil. You don't necessarily know if the person used a form of dagga that has the psychoactive ingredient, which is the THC. So it's important for employers to look at which test should actually be imposed in their workplaces. It's not a one-size-fits-all. And, there's costs and there's time limits that are linked to these tests. In the Marassi case, the court then found that there was no unfair discrimination. A big focus was on what this person actually did on a daily basis. And the court also found that because he didn't lead expert evidence on these specific tests and the inadmissibility of the tests, the court had no option but to go with the evidence which we led, which was the occupational health and safety personnel that just said, this is why we impose these standards or these cutoff limits, and this is why we use these tests. I think just from a strategic level, when employers are running these cases, they need to look at who the actual onus is on when they decide which evidence to lead and which experts to bring in. I'm going to move on to the next case, which is the Innover case versus Barlow-Wool. This case was not a Section 6 claim in terms of the Employment Equity Act. This case was a automatically unfair dismissal case. And the difference between this case and the Marassi case was that a zero tolerance policy was applied here. It was applied across the board to all of the employees. And the court here looked at the difference between alcohol users and dagga users and explained that when you apply a zero tolerance approach, you're saying to alcohol users, you can still use, because if I drink today, it's not necessarily going to show up on the test tomorrow. It's saying to dagga users, you can't use it all, because if I use it today, it's still going to show up on a test in 6 weeks' time. So there was this practical issue had to be addressed. And if you're going to use the inherent requirement defense, you need to then, there's an even bigger obligation on you to show why this specific employee, the zero tolerance approach should be imposed on this specific employee, given their job and given what they do in the specific workplace. The court found there wasn't a rational link between the zero tolerance approach on this employee and the health and safety in the workplace. And that it cannot just be an operational convenience consideration or wanting a one-size-fits-all approach across the organization. So there we got 24 months compensation was awarded, and there was the court found that it was a violation of the employee's privacy. Just some key takeaways from these judgments is just because an employee, for instance, works from home or has an office-based job, it's not to say that there can't be a cutoff limit or a zero tolerance approach that's going to be imposed. You need to look at what that person is specifically doing. So are they working with confidential information? For instance, financial information. What is the risk of that person doing their job when they are likely to be impaired? And that is the wording that was used in the Marasi case, is likely to be impaired based on the cutoff limits in the international standard. Are there other jobs linked to that person's job, which places a risk on the company? So in the Marasi case, you've got someone that needs to make sure that the operational or the emergency phones are operational. Who actually uses those phones? Why is it imperative that Mr. Marasi does his job properly? Where does that person have access to? So for instance, the fact that someone is an office-based employee, are they actually working in an environment which is high risk? So are they going into the bunkers? Are they going, is there big cables, which poses a risk if you know it was pulled out? Those small details are the things that you need to go into when you assess what evidence you have to present in your case. And then, as I also said, the cutoff test, the cutoff limits and the tests. What is the correct practical measures that you need to impose? Should you go zero tolerance, or should you actually impose a limit in terms of those international standards that Petra SA used? And the text, go look at the cost considerations, go look at what is practical for your business in terms of how long these tests take to give you the results. So that's their DACA issue. Then I'm just going to touch on religion and criminal records quickly. In terms of religion, we had the Sun International versus Saiti case from October 2024. The important thing that came out of that case is the majority distinguished between Section 6 claims in terms of the Employment Equity Act and Section 1872A claims, which is automatically unfair dismissal claims in terms of the Labour Relations Act. And what the Labour Appeal Court found there was, when you look at the definition in 187 for automatically unfair dismissal disputes, it says that unfair discrimination may be fair if the reason for dismissal is based on an inherent requirement of the particular job. So that means that an inherent requirement is not an absolute defense when you come to automatically unfair dismissal claims. That is different to Section 6 Employment Equity Act claims, where it is an absolute defense, as was found in the case with Marasi. If you are dealing with automatically unfair dismissal claims, you've got a further step that you need to follow, which is the reasonable accommodation requirement. So the court there said that employer must demonstrate that it's not possible to accommodate the employee without causing undue hardship or insurmountable operational difficulty. And then the court went further to say this is a factual inquiry that requires an objective test. So when, I'm talking to the lawyers and the ER managers and HR managers here. So when you get these cases, the first thing to look at is this a Section 6 claim in terms of the Employment Equity Act, or is this a Section 187 claim in terms of the Labour Relations Act? Because that is going to determine what your actual test is and whether you have to deal with the accommodation requirement. In terms of criminal records, we had the O'Connor case versus LexisNexis that came through in April 2024. The important, I think, issues in that case was, we've seen a lot about this, the criminal record thing, and employers firing employees when, just saying, if you've got a criminal record, you can't work for us. The court here referred to the Code of Good Practice on integration of employment equity into human resources policies and practices. Now, there's so many of these codes of good practice that we don't work with on a daily basis, and it's important to actually go and have a look at those codes when you draft your policies. The specific item that was referred to here was the one that spoke about you can't discriminate against an applicant unless, or you can't focus on criminal records unless it's directly relevant to the job requirements. This was a person where having a criminal record didn't pose a risk to the business, because the person was working remotely and they were basically just, it was a person that was just checking the cases. So on all of these inherent requirement defenses, it's important to go look at what does the person actually do. If you're going to use the criminal record defense, was this person a cashier? Are they a CFO? Is this an attorney where there's a fit and proper requirement? You can't just say we want all our employees to have a clean criminal record. From a practical perspective, I think it's important to go look at what these codes say and to look at whether the policies of the employer are in line with the guidelines in these codes. This specific code that was referred to in this case actually refers to an audit being conducted on all employment policies and practices. That's from the job description phase, adverts, interviews, reference checks, inductions, all the way through up until, your day-to-day working once the person's been employed. You need to check that all of those practices and policies don't have these discriminatory requirements. And if it does have, that it is, that it's still fair. That's it, Neil. Good timing.
I'm going to cut you anyway. Yes. Thanks, Jeanette. Look, to me, the discrimination issue is extremely important, particularly in a rights-based culture that we live in now, with diversity in the workplace and those sort of things. I think we're in a situation where we're likely to be more conflictual, and the issue is not just a difference of opinion; it boils down to issues of discrimination. But and you did deal with it in your talk. I thought it was great. But a casual reader who's researching the law for their case at the CCMA may think that the Marasi and Inova judgments contradict each other, or they create different principles. But if there was, it really boils down to the policy choices of the employer at the time, isn't it?
So that's exactly it. I think, yes, it does look like the judgments are conflicting each other, but the importance is it was different kinds of disputes that were referred. That's the first thing that needs to be looked at. And the second thing is the focus of the evidence that was led was different. So Marasi, a very big focus was on the day-to-day linking. They were able to link it back to an inherent requirement of the job, where they weren't able to do that in Inova. And then also, I think a big thing that came through in these judgments is just the sensitivity that employers need to apply with this. You want to show that you are sensitive to these issues and you understand that it's a cultural and religious issue, but this is actually a general operational requirement to ensure that everyone in the workplace is safe. This is not just a one-size-fits-all or a decision for the sake of convenience.
Correct, yeah. All right, and then I'll touch on it a bit later at the end, but just from your perspective, because it falls under this heading of discrimination, what do you expect to see happen with the Employment Equity Amendment Act? It came into effect on the 1st of January. And then the sector numerical targets. What do you think is going to happen with all of that?
So I think there's been a lot of posts about this also on social media. We've all seen the summaries on what it actually entails. I think a lot of the employers below 50 employees are going to be happy that they no longer have to comply. But I also think there was a lot of non-compliance in that sphere. So I think that's pretty much not really going to result in a change. The sectoral targets were posted in draft format for comment so long. So we are waiting for that to come in this year. There seems to be some confusion also about whether it's final and actually binding yet. And I think the biggest issue that we're going to see is there's a bit of confusion with employers as to whether there's just national sectoral targets that have to be met, or whether you still have to look at the national and provincial, what they called EAP, so the economically active population, how these things interact. You still have to set your annual targets based on those EAPs, economically active population, based on the different levels of, or the different categories of designated groups. What is going to come in, though, is a 5-year plan or a 5-year cutoff, which is a minimum that you have to meet for the general grouping of designated persons. And that has been split into male and female. So it's not that the EAP requirements or annual targets have fallen away. They've sort of just given a cutoff at the end, which has said you have to meet this minimum within these sectors. The biggest issue I think that we're going to sit with is these certificates of compliance that now need to be issued when you're going to do work with government. And those certificates, when they are going to issue those certificates, they're going to look at your unfair discrimination awards in the last 12 months. So it is so important for employers to get their ducks in a row in terms of their unfair discrimination policies and any pending cases that they have at the moment that deal with unfair discrimination, so that you don't have scathing or negative awards that affect the issuing of those certificates of compliance. I think we're going to see probably some litigation on specifically that issue, where employers are precluded from getting government contracts because they just can't get the certificates.
Yeah, I think you're right. Thanks, Jeanette. That was
Thanks,
very
guys.
All right. Next up, I think let's pass it over to James Horn, also down in the Cape Town office. He's got his jacket on today. He's one of our partners. He'll be dealing with retrenchments and Section 197 issues, which is an absolute minefield. So good luck, James.
Thanks, Neil. I intend to be incredibly brief, and don't ask me any questions that are too hard, at the end. Listen, the first case I want to deal with is Umicore Catalyst v. NUMSA. And here the LAC is faced with a large-scale retrenchment, and part of the employees affected by that retrenchment are laboratory employees. So for the non-laboratory employees, the employer uses LIFO as a selection criteria. But for the laboratory employees, it decides that skills retention is a more appropriate selection criteria. Nothing unusual so far in this, and it's quite common for employers to apply different selection criteria to different categories of employees affected by a retrenchment. So in order to assess the skills of the laboratory workers, the employer conducts so-called behavioral assessments. This is done by way of the circulation of a questionnaire that's then considered and scored by a panel of persons appointed by the employer for that purpose. Still nothing unusual. Questions in the questionnaire are asked with the aim of assessing problem solving, multitasking, communication, initiative, and enthusiasm. And really, it's a bit like a job interview. There's then an objection to the objectivity of this process by one of the unions. So in addition to those items in the questionnaire and the scoring of the panel, the employer decides that it's going to use objective criteria also, such as past performance appraisals, disciplinary records, attendance registers. All of these are factored into a scoring matrix. Now, for many of the people listening, you will have applied, I'm sure, the similar processes in retrenchments that you run. Ultimately, there's no agreement in respect of the retention of key skills for the laboratory workers as the selection criteria, and the employer therefore has to show that these are fair and objective. And the Umicore judgment deals specifically with the second part of that, which is assuming that they are fair, are they objective? And in finding that they were not objective, the LAC makes a number of really quite remarkable findings. The first one it says is that the questions in the questionnaire are subjective because some of the questions focus on personality characteristics like initiative and enthusiasm for the job, etc. So those are not objective criteria per the LRA and should have never been used. In respect of past performance, what the LAC says is, well, it decries the fact that there's no on-the-job performance evaluation in respect of each individual affected employee, remembering that this is a large-scale retrenchment process. On the assessment of attendance, the court takes the view that employees could be inadvertently punished for exercising their statutory rights to annual leave and study leave, etc. And the court doesn't decide on whether past disciplinary records are objective, But what it does do is assume this in favor of the employer, but simultaneously cites the 2002 judgment of the Labour Court, Singh and others v. Mondi Paper, which cautioned against using previous disciplinary records at all. And the implicit suggestion in this is that if the court is called upon to decide the lawfulness of, past disciplinary records as an objective criteria, it may very well find that this is impermissible. So ultimately, the LAC agrees with the Labour Court and says the selection criteria are not fair and objective, and it denies the appeal. The judgment is really, this judgment is a warning shot for employers who use skills retention rather than LIFO. LIFO is, of course, presumed to be fair, and the next judgment I deal with will cover LIFO. It begs the question, how does one assess skills on an individual objective basis? Some suggestions, I think, are that performance assessment panels, akin to interview panels, should be avoided at all when you're doing a skills retention assessment. Reliance on prior disciplinary records and attendance, this is likely to be challenged by the unions. If attendance is used as a criteria at all, then it ought to be limited to a record of late coming based on clocking system data or something like that, but not any sort of attendance related to sick leave, even unpaid special sick leave, or any other form of leave is going to be problematic. The focus should be on whatever entirely objective criteria can be found. This might be experience, qualifications, etc. On performance, you need measurable performance targets, sales targets, productivity targets, output quotas. Can you measure these for your affected employees and rate them accordingly? And skills, if you're going to assess skills, how do you do that? Well, you're going to need to have industry-accepted skills tests that need to be applied, rather than a sort of particular management team's feeling of the skills of a particular person, which runs the risk of becoming subjective. And past performance should be used with extreme caution, if at all. So, in our view, the judgment is concerning in a lot of respects. It's incredibly difficult, as I'm sure you all know, especially in a large-scale retrenchment, to measure with absolute objectivity someone's skills. So, I asked the question, for example, for an HR business partner. Let's say 5 of your HR business partners are affected by a retrenchment, or for that matter, the attorneys in our firm. How can we objectively measure the skills of each of those persons? There is no necessarily prevailing test. Targets may be different, or there might not be targets at all that you can compare apples with oranges with. So the court has really set the standard of objectivity at an incredibly and perhaps unreasonably high level, and so much so that it may make it very difficult to reach. And the intention is clear. It's to say depart at using LIFO as a selection criteria at your own peril. The problem, and the second judgment I'm going to deal with, is Fisher Tube Technic v. Bayen and another, is that LIFO is an incredibly problematic way of conducting retrenchment exercises also. So in this judgment, Fisher Tube, the LAC is dealing with all of 2 retrenched employees retrenched during a small-scale retrenchment. The reason for the retrenchment was that their positions had become redundant and they were offered positions at a lower level with reduced terms and conditions of employment. This is sort of vertical bumping, and in fact, it's the union that proposed the vertical bumping and the employer had obliged. The focus at the Labour Court was on the distinction between vertical bumping and horizontal bumping. And as you all know, vertical bumping is where you move down to a sort of lower position, typically with lower remuneration and benefits, whereas horizontal bumping would be taking a position of an employee on the same or a similar level with less years of service, and typically on a similar remuneration package and with similar benefits. Very worryingly here, the Labour Court took the view that the employer should have, of its own accord, in fact, not should have, was obliged to, of its own accord, assess the possibility of horizontal bumping. And then, because it didn't, of its own accord, do that, and then didn't lead evidence at trial to show why that was not a viable option, the dismissals were found to be substantively unfair. Rightly, we would say, setting aside that judgment, the LAC notes that the evidence demonstrated that the union had raised vertical bumping, and the union knew or ought to have known that where you engage in vertical bumping, there's likely to be a reduction in terms and conditions of employment. The problem with bumping is that it can generally be a very bad option in a retrenchment exercise. Where you start to bump one employee for others, it can expand the group of affected employees swept up in a retrenchment exercise. It can give rise to a chain of bumping. It can lead to talented employees who inadvertently get swept up in this, perhaps newly appointed employees, looking for alternative employment, and you might want to retain these people. It can result in the long term in the wrong employees being placed in the wrong positions and cause sort of longer term problems. And generally, it expands the negativity associated with the retrenchment process wider across the business. This is less of a problem in major companies, but in small to medium-sized companies, if you engage in bumping, vertical and or horizontal bumping across different positions, it really becomes an incredibly disruptive thing to the business. So we sort of between a rock and a hard place here, because you have the problem with the skills and the objective assessment as a selection criteria, and we also have this renewed sort of focus on bumping for LIFO, and so it really is a very difficult and vexed position when you need to engage in a retrenchment. I'm going to move quickly onto, and very briefly, onto Coca-Cola and the Constitutional Court's decision in Coca-Cola Beverages v. the Competition Commission. I don't intend to go into the facts here, but in essence, as part of certain merger approval conditions, there was a limitation for Coca-Cola engaging in retrenchments for a period of time, provided that those retrenchments were linked to the merger. The judgment is interesting from a legal perspective, and in particular, the test to be applied when assessing whether there is a breach of the merger conditions. And you guys might all recall the old judgment of NUMSA v. Avenge, Tried and Steel, where the Constitutional Court had split 5-5 on whether to apply the proximate cause test, factual and legal causation, for determining the true reason for a dismissal, or whether you apply the dispute of facts tests, the Stellenbosch Wineries SCA judgment test, to determine the true reason for the dismissal. And this legal test is again an issue in Coca-Cola. What is the reason for the retrenchments? The Constitutional Court here again equivocates, but prefers the proximate cause AFROX test. This is the factual and legal causation test. In the first instance, the Constitutional Court notes that there would almost always be factual causation between merger conditions prohibiting a retrenchment and the subsequent retrenchment process that took place during the term of that limitation. But in respect of legal causation, which is the second leg of the test, the court notes that firms are dynamic institutions, and not every change that results post-merger is necessarily attributable to the merger. And that approach it held is far too mechanistic, and changes can be conceived of a firm's behavior, even post-merger, that would have happened in any event and cannot be thought of as merger specific. And effectively, it looks at the tribunal's ruling and says, well, there was insufficient evidence to demonstrate that the principal reason was for the retrenchments was the removal of duplicate roles, and it prefers Coca-Cola's version, that the sugar tax was the reason for the retrenchments, and it had nothing to do with the merger. Therefore, there's no legal causation in respect of the retrenchments, and there's no case. The very interesting part here, I guess, is what is the Competition Commission going to do about this? And I suspect the answer to that question is they're going to, instead of saying you're not allowed to retrench based on merger conditions, they're going to say you're not allowed to retrench at all for a period. If that happens, then there will likely be a constitutional challenge to say employers have the right to fair labor practice under the Constitution, and they have a statutory right under the LRA where their operational requirements justify a retrenchment. And so that might give rise to a debate about the supremacy clause in the LRA. And then finally, I think if the Competition Commission is very clever, and or trade unions, what they'll do is they will make a merger dependent on the conclusion of a collective agreement with the unions, which provides for no retrenchments for a period. And that would then become a labor court enforceable agreement under the LRA, and that might pass constitutional muster. So a very interesting judgment indeed. Neil, I can see you've come back online, so I will skip Regenesis and Avis and a whole bunch of the other ones. Do I have time to discuss briefly a 197 judgment?
No, unfortunately not. And if you start with Regenesis, we'll be here till next week. So
I'll put the citations on the YouTube link.
No, sure. We'll do that as Jeanette mentioned on the YouTube videos. But it seems to me, I mean, Section 197 has always been, from a legal certainty perspective, an absolute disaster.
Yeah.
And it seems that retrenchment is going that way too. So it seems to me that, you know, initially the courts were kind of happy to defer to an extent to the employer's decision to say the employer's best placed to determine why it restructured the way it did. But we've moved from that entirely. And now it seems that the courts are quite happy to scrutinize the very reasons that the employer wants to run its business the way it does. Have we reached that point?
If I had a keyword that described the various judgments recently of the LAC, it would be persnippety on technical points. It is a very under a microscope view at a large scale retrenchment to focus only on objectivity. And some of the requirements are objective, but to say, oh, well, a few of them aren't, so this whole retrenchment exercise is unfair, is a very harsh on the employer. So yeah, Gail said you need to be organized and prepared. I think the judgments call for hypervigilance before a retrenchment process. I think the older judgments, to be fair, struck a more balanced approach. And perhaps here's an area where we need the Constitutional Court to weigh in. On 197s, you know, a labor court, one of the doyens of labor law in South Africa had recently said that this area of law is entirely settled because it's been dealt with by the Constitutional Court so often. And he's right. There are maybe the most Constitutional Court judgments in employment law are based on 197. Yet the way the courts apply the test on a fact-by-fact basis, it diverges wildly. And so I don't have an easy answer there. I think you're right. There is no clarity. It's a vexed thing. And really, it might be dependent on whoever is your assessor of facts in a particular case rather than a particular legal principle.
Yeah, no, fantastic. Thanks, James. That was very insightful. And I think this is not the last word on retrenchments. I'm almost sure there will be further developments. Right, last but not least is another partner in our employment practice, Jessica Fox, who has a passion for restraints of trade, which have become very popular again. So take it away, Jess.
Thanks, Neil. And hi, everyone. Thank you for staying on this long. I know it's been a quick but long webinar. In any event, so I went through most of the cases that dealt with restraints in 2024, and there's a lot of them. So I really wanted to focus on the cases which would actually be of benefit to employers. And I think specifically for financial service providers and for other service industries, one of the most prominent cases was the Advice Works versus Rue case, and that was released in February 2024. Effectively, what happened here was 10 financial planners of Advice Works resigned and joined Wealth Associates, who is a direct competitor. Both Advice Works and Wealth Associates are in the business of wealth management and the provision of investment advisory services and products on behalf of its clients. And its financial planners are the people that administer and maintain those investment portfolios on the part of the individual clients and also provide them with financial advice. The impact of these 10 former financial planners leaving is that they serviced about 1,918 clients of Advice Works. And when they departed, 820 of those clients also left and joined Wealth Associates, and a further 433 of the retained clients only kept a partial mandate with Advice Works. So it's needless to say that there was a bit of damage done. And particularly when the value of those clients amounted to about 2.5 billion rand. So naturally, AdviceWorks would seek an interdict to restrain those employees from joining a competitor and also from soliciting their clients. This case is very lengthy for those of you who have read it. So I'm not going to deal with issues of unlawful competition. I think it's something that is coming about more often, but for the purposes of this webinar, I'm going to focus on the key takeaways for the restraint issue. And firstly, I want to confirm, or it was interesting that the Labour Court confirmed that for financial service providers, client information or their client base is considered a protectable interest because it actually forms part of their goodwill. And without that goodwill, a financial service provider's business is of little value. It also confirmed that the relationship between a financial planner and the clients are not only direct and close, but it's marked on trust and confidence. It's easy for a financial planner to take up that client with them to where they go, and they can be moved easily. Secondly, or thirdly rather, in respect of the defenses raised by the employees or the financial planners, the first defense was that of the fact that they did not directly solicit the clients of AdviceWorks. They said that it wasn't me. The clients actually followed them on their own will, on their own accord, for their own reasons. So therefore, I didn't breach the restraints. And the Labour Court rejected this defense. It said that this defense would be unattainable. And if you actually followed that logic, then you couldn't ever really enforce a restraint on the breach of a non-solicitation clause. And that it actually forms indirect solicitation, and therefore it would be a breach of the restraint agreement. What was interesting, however, was what the Labour Court held in respect of this issue of indirect solicitation. And I'm going to read the paragraph. It's paragraph 147. It says, in casu, the restraint of trade nonetheless makes specific provision for indirect solicitation. That being so, and even if the individual respondents were approached by the clients they serviced at ADX, of those clients' own accord and initiated no contact themselves with those clients, it simply does not matter. What the individual respondents needed to do was to turn those clients away and inform those clients that they cannot be assisted because of the restraint of trade. And I thought that was an interesting comment, because it almost puts a duty on the employee to actually turn away clients that are actually trying to follow them to the competitor. And I thought that was an interesting point. So something we could probably raise in future if we ever had to bring a restraint. And then finally, one of the final key takeaways, I think, which was important for this webinar, was the defense of exceptio non-pleti contractors, which is really the defense of reciprocal performance. And for the lay people in the webinar, that just means that if one side or one party doesn't perform in terms of the contract, then the other party says that they weren't obliged to perform either. And what the financial planners had raised in this matter was that because AdviceWorks did not perform in terms of an ownership participation agreement, they didn't have to observe the restraint, which fell under the employment agreement. But once again, the Labour Court rejected this defense and said that the ownership participation agreement and the employment agreement are completely two separate agreements. And furthermore, if you want to rely on this defense of reciprocal performance, you firstly have to make sure that the benefit is quantifiable, tangible, and deliverable. And secondly, it must be explicitly stated in the contract that the restraint and non-solicitation undertakings are subject to the provision of any such benefits. And I think that was really critical to set that out, because you see a lot of this. And it actually leads nicely to the second case, which I'm going to deal with, which was the AON South Africa versus Smith matter. This is a May 2024 decision. It wasn't reportable, but a similar principle of the defense of reciprocal obligations was raised. The facts, however, are important because in this case, Smith signed a restraint of trade, but in that restraint of trade, he said that he was signing the restraint as part, because in consideration for all benefits that he would receive as part of his employment up until the date of retirement. So what really, the main issue which was dealt with here was whether the bonus was considered a benefit for which he agreed to sign the undertaking for. And the employer, I suppose, didn't dispute that the bonus was due, and therefore the court upheld the defense of reciprocal performance, stating that the performance was due in terms of the employment contract. Smith had signed the restraint specifically in consideration for the receipt of the benefits, including the bonus, and therefore he was not obliged to observe the restraint. And then just quickly and briefly, a December decision of Waco Africa versus Ahmed, sorry. And I'm not going to go into any detail of the facts here. It's really run of the mill. But what was important was the fact that the employer intended to enforce a unique kind of duration of the restraint. And I'll go into the detail now. So basically, the agreement said that the respondent was restrained for a period of 1 year from the date of termination of the agreement, but that if any of the provisions of that agreement was subject to litigation, then the restraint would only run from the period for a period of 12 months after litigation was finally concluded, or from when the employee actually stopped breaching the restraint. The employee argued that this was more of a punishment if he challenged the reasonableness of the restraint, and that it couldn't be enforced on that basis, and it went against the purpose of a restraint. And the Labour Court agreed. It said that the purpose of the restraint is to protect the employer's proprietary interests, and the protection it affords commences from the date of termination of the employment relationship and becomes enforceable upon breach. And the court took issue with the fact that the employer was trying to rely on the final order or when the matter was finally concluded, because that could be at the Constitutional Court. And so this poor employee would be restrained for years until there was a final outcome on the matter. And interestingly, because the employee was partially successful in defending the matter, he was only required to pay 20% of Waco's costs. And just to conclude, and I think specifically around the issue of the reciprocal obligation defense, you need to make sure that you pay any consideration that you've agreed to. We had a matter last year where the employer was ready to launch an urgent application at the Labour Court. Silk had drafted, and then we advised them that they hadn't, in fact, paid our client the consideration, and that obviously brought a quick end to the proceedings. So you need to be careful. You need to do your due diligence, make sure that those things are dealt with.
Absolutely.
Yeah.
Thanks, Jess. I just have one question for you. You would know yourself that in the office, we've been flooded with queries on restraints probably over the last 6 months. And we've had litigation and drafting restraints of trade and looking at garden leave issues. Why do you think there's been this kind of focus on restraints in the last few months?
I think, Neil, there's a lot of reasons, but I think the main reason is that we are currently facing a stagnant market. And I think employers are desperate to hold on to their market share. And when an employee leaves, there is a threat to that market share, specifically if they're going to a competitor. So I think it's a sign of the economic times, but also I think there is a real fight for key and critical employees, where I think there is a scarcity, and people are getting tired of the constant poaching. So I think that's probably why we're seeing an uptake in these cases.
And you've got pressure from external factors like BEE and employment equity, which also feed into why you would want to restrain someone from leaving. All right.
And digital advancements, it's becoming more readily accessible. So there's a lot.
Fantastic. Thanks, Jess. That was great. Just in closing, I think you can see that there's been a whole lot of things that have transpired in employment law over the last year, and we just skimmed the surface, really. We kind of chose the most interesting and important ones. But that was last year. What should we be looking out for in 2025? Obviously, and Gail mentioned it, is that there's a draft code of good practice on dismissal, which is already out. And that's just part of a series of changes to our employment laws, which are in the pipeline. They're on their way in. In the case of the Employment Equity Act, that is already in, and now we're just waiting for the regulations to be finalized. There is another round of public consultations, I understand, and employers would do well to attend those sessions, where they're discussing in particular the sector numerical targets. But I think we can expect a court challenge in due course on those issues. In relation to the legislation changes, are we going to see the sort of changes that will get business going and jobs being created? Unfortunately, I don't think so. Early indications are that we will not see that. There's going to be a lot of tinkering with existing provisions rather than a wholesale redesign, perhaps, which frankly I think is overdue. We're 30 years into the Labour Relations Act, and it might be time to rethink things. There's whistleblower legislation, which is also in the pipeline, and its primary focus is to protect whistleblowers, and employers will need to prepare for this. We spoke about this at our conference last year. A bill is likely to emerge at some point this year for comment, and that will impact employers directly. We, just as an aside, we specialize in whistleblowing complaints, investigations, and best practice, and we've actually submitted comments on the draft legislation, which is frankly quite radical. So as employers, I think you should get on top of that. There's also an increased focus on mediation. There's been a call for a Mediation Act to be promulgated, requiring compulsory mediation. And we know as labour lawyers that mediation is an excellent tool to resolve disputes. The CCMA tells us that most of its disputes are resolved at mediation or conciliation stage. So, but, you know, regardless, employment disputes are unavoidable. But it's important that employers have the right tools at their disposal. And I think Gail spoke about it, is to be prepared. But not all disputes need to last for months or years on end. And I think employers should consider the option of mediation. It's already required at the CCMA, but if we're not getting past an issue, perhaps we should be focusing on mediation. And I think that's about it in a nutshell. We hope that you've enjoyed the webinar. Thank you to all of you who attended. And I think a big thank you to all of the speakers. I think they did a fantastic job. Please keep an eye out for our other webinars this year and conferences we'll be hosting. Also, please check out our YouTube channel and remember to follow us on LinkedIn, please. We do post regularly, and make sure that you don't miss any updates. So we look forward to seeing you all soon again. Thanks very much. Bye.